Namaskar. I am today continuing our conversation on how to be using legal theory to teach law critically. If you recollect, in that first video, I had said to you that we can use theory to be asking why questions instead of only doing what with our students. I am going to be using this insight today to speak with you on the theory of legal personhood. This presentation of mine I have divided into 4 halves. Firstly, I speak with you on how do we define legal personhood. I then go on to talk about how it has been constituted over time and context. I next dwell on its relevance for all of us in relation to the various areas that we teach. And lastly, I demonstrate how deconstruction helps critique. How is legal personhood constituted? What you find across theorists almost, that they say that a legal person is one who is a bearer of rights as well as has the freedom to act. It is only if you have both these attributes are you seen as a full legal person. The significance of this definition is that whilst some people are legal persons, all human persons are not legal persons. Who are the human persons who are seen as legal persons and who are not? That is, how do we constitute legal personhood? Roscoe Pound, in volume 4 of his jurisprudence chapter 25, had a long chapter on legal personhood, or persons as he called it. And in that chapter, he looked at the constitution of personhood from Roman times to current day, looked at Roman law, French law, German law, Anglo-American law, and in fact, courtesy the sacred books of the East, even Hindu law. What he did find in that construction basically was that personhood was conferred in every society depending upon what kind of system were they privileging. So when you're using slavery, or slavery was at the bottom of your economic system, slaves were not given personhood. When you were in the feudal era, you kept out serfs. When you were talking in terms of the importance of the patriarchs, then dependents and even adult sons were denied personhood. Women's subordination in terms of personhood came in with unity of coverture, so a woman could not herself sue or be sued. The entire narrative of Pound brings home that how personhood was used as a mechanism of exclusion, but more importantly, it was used as a technique of reinforcing whatever kind of economic, social, or political structure a particular society wanted to privilege. At the end of his narrative, which was, like I said, ran through a lot of ages, Pound came to this conclusion that this kind of composition of personhood, or this way of using personhood in a disqualifying manner, was a thing of the past. Increasingly now, we are starting to be looking at personhood in a universal way. The deficit mode of looking at personhood is a thing of the past, and only people who are being denied personhood now are dependents or people with deficits, and hence he sort of spoke in terms of personhood as a universalizing or a subject creation technique. The question that we need to be asking is that, okay, Pound did not problematize the denial of personhood to defectives and dependents. He felt it was a protective role of the law and hence unproblematic. How problematic it is something that I will address in a separate video, which I have termed the theory of disability and personhood. What I want to be doing with you today is to revisit the other conclusion of Pound, where he speaks in terms of that we have actually this very selective conferment of personhood is something that is a thing of the past. I want us to ask that is it really so? We can address this question in two kinds of ways. One is to be asking whether this is the normatively still there, that is questions of slavery, indentured labor, bonded labor, all of those manners in which the economic system kept people out. The whole question of in socially how we excluded people where women were not given full legal capacity, or you were privileging different members of the family in terms of legal status and legal personhood. The other is to be asking the same question really, that okay, normatively it is no longer there in the law, but is it there in practice? The second question I want us to take off, to ask in relation to the query that Pound, or the conclusion that Pound reached, is that okay, those categories of exclusion that Pound dealt with in great detail in his narrative may not anymore be there, be it normatively or otherwise. But have we, in our times, created other categories? Have we, in order to reinforce the system that we have, created other ways of doing exclusion? And I think this is a very fundamental kind of question. So when it comes to issues of, I would say, when it comes to the power of the patriarchs, if we look at the entire Hadia case that just happened for us, and we have a grown-up woman who has made a choice of marrying a person who she thinks she wishes to marry, and the entire force of the law, not just the father, but the Supreme Court of the country, the high courts as such, believe that they have to protect the woman from her own choice. Is this something that we can really speak of as recognizing the full capacity of a woman as a person before the law, a major woman, a professional who is making a choice as to who she wishes to marry, and the entire legal system is telling her that we will decide whether this is a wise or not a wise choice? Is this a throwback to the kind of power that the patriarch wielded at a certain point of time? Is it that though in the norm of the law we have changed, but have we changed in the practice of, in social practice, and to some extent, though ultimately the Supreme Court got it right, but even in the practice of the law, have we really given up those ways of excluding certain people or believing some members of society to be less legal persons than others? In relation to the second point that I had made to you, that we also need to be asking that have we possibly substituted the grounds of exclusion which existed in other times and eras to reinforce their economic, social and political systems with our own? How is it that we look at, say, the undocumented worker today? The very fact that we allow people entry into a country, do not give them any kind of registration, let them do work, but keep them outside the pale of legality. And because we keep them out of the pale of legality, their bargaining positions vis-a-vis their employers, what is it that they can seek from them or not seek from them, and the fact that they are really speaking cheap labor who can be used as the employer wills because the law has not accorded them recognition. How do we look at the whole phenomena of the illegal immigrant? This is like you have to contrast this with the open border policy which all of us kind of read about when we read the narratives of travelers coming into our country, in our travelers going elsewhere. It wasn't, nobody really had to be seeking a visa before they went in. If they didn't like one place, they could go to another. And from there onwards, the manner in which we have started to exclude a whole range of people. The point of this entire narrative or this entire constituting of legal capacity is to demonstrate to you that really speaking, who we see as a legal person and who we do not has a lot to do with the kind of system we wish to establish and reinforce. It has nothing whatsoever to do with the inherent value of that human person. Now, how is this particular insight of relevance to all of us across various areas of law? Because irrespective of the field in which we are specializing or what we are teaching, be it labor law, or be it contract, or be it family law, be it property law, every one of us has a certain subject, somebody who's entitled to contract, somebody who can manage or not manage a property. Do we narrate all of those requirements of the law as only these are the rules of the law? This is the kind of person who is entitled, and this is the kind of person who is not entitled. If we carry on in a uncritical way, or we carry on in an information driven way, then we will only do the what. But if we keep in account the point, the entire analysis I've undertaken with you today, then we start to asking why. Why is this particular person recognized as a person before the law, and why is the other not so recognized? And the one who is not so recognized, who is that person? How is this existence of this illegal or this person who's not a person before the law in some manner strengthen the system as it wants to subsist? How does the illegal immigrant in some manner strengthen the whole notion of nationhood, that we control our borders? How is it that the person who is not a worker is in some manner providing work but not getting the bargaining positions which a worker should get who has given in his labor? And it's in that manner that each of us, because we have subjects of law who are the critical players in the area in which we are teaching, that we get an opportunity of asking, why is this particular category of person a person before the law, and why the other is not? I have raised this entire issue, keeping the matter of disability and impairment out. That I will discuss with you in the other video. The point I just want to underscore, that if we do not deconstruct persons before the law, and we only narrate who are the persons before the law or what is legal personhood, but not why this is personhood and the other is not, we are not able to really comprehend why our systems that we teach are the way they are. The entire exercise today was an attempt at demonstrating that deconstruction has within it the seeds by which we can build critique. We can start to see both what the law is, what it ought to be, and also why the law is how it is. I do hope that we can carry on this conversation in relation to other issues and other areas, and keep seeing for ourselves that what is the manner in which legal theory or theoretical understandings can help us to teach whatever we are teaching from a more critical as well as a more questioning lens, a questioning which when we do for ourselves, we of course also teach our students to do. Thank you so much.